Everyone. I want to welcome you today to today's event. My name is Jennifer Funes with Cal Optima Health, and on behalf of the County of Orange, California, and our World Elder Abuse Awareness Day Committee, I want to welcome all of you to the 2023 World Elder Abuse Awareness Day event. First, we will start with some housekeeping items. This presentation will have live interpretation of American Sign Language, as well as Spanish and Vietnamese. You should now see instructions on how to select your language on a laptop or a cell phone. On your laptop, you will see the globe icon on the bottom of your screen. Then click on the globe icon to make your language selection. On your cell phone, you will need to find the More icon with 3 dots above it. Then click on it and select Language Interpretation. After clicking on Language Interpretation, click on the language you would like to use for this webinar. Please select your language for the presentation now. We will pause briefly to allow everyone to make their selection. All right, now for some housekeeping information. This webinar is being recorded
Este webinar está siendo grabado
and will be available to all
y
attendees
será
in case
disponible
you would
para
like to go
todos
back and reference any of our slides,
y
resources, and other materials.
otras.
You have all been muted by our webinar administrator, so we can avoid any unnecessary background noise. Your audio, how loud we sound to you, is controlled by you though. You can adjust your volume on whatever device you're watching us on. The hand raising feature has been disabled too, which leads me to our next agenda item, which is how to ask questions. What you are seeing now is a screenshot of the Q&A box, otherwise known as the question and answer box. During the presentation, you will be able to type in questions for our presenters. We have committee members reviewing these throughout the presentation and will ask the questions of our speaker at the end of their presentation. Your question also might be responded to with some helpful information and links. Please remember not to wait until the end of the presentation to ask your questions, as we will be gathering these questions for the speakers throughout their presentation. And now for some background history. World Elder Abuse Awareness Day, otherwise known as WEAAD, was launched on June 15, 2006 by the World Health Organization to promote a better understanding of elder abuse and to shine the light on the need to recognize and defeat elder abuse in all of its forms: emotional, psychological, physical, sexual, financial, and neglect around the world. In 2011, President Barack Obama issued the first official presidential proclamation naming June 15th National Elder Abuse Awareness Day. Not long after that, the governor of the state of California and the Orange County Board of Supervisors followed suit. WEAAD events have been happening for roughly 12 years now. Attendance at WEAAD conferences has topped 400 over the years, and now there are 20 to 40 WEAAD events that happen annually around the United States, Canada, and include events from numerous other countries as well. Our hope is for professionals and the community at large to become more aware of elder mistreatment and to empower older adults and the people who love and care for them. So thank you again for joining us today. And now I will hand things over to Maika.
Orange County. Yeah.
Thank you, Jennifer, for that wonderful welcome. My name is Maika Bledsoe with Human Options, and I will be your moderator for this webinar.
Yeah,
I'd also like to let you know there will be a link to closed captioning in the chat box. We'd like to thank our sponsors today.
Yeah,
Optima Health and Radiant Futures. Radiant Futures has sponsored our opportunity drawing. If you participate in the survey following our webinar, you will be entered into an opportunity drawing to win a $250 gift card from Amazon. There will be a total of 25 winners. You must provide your full name and age range when completing the survey in order to be entered into the drawing. Next, you will see the overview of the webinar. You will hear from two guest speakers today, Katherine and Edie Mermerlstein, who will be speaking on our theme of resiliency and aging. Once each presenter has spoken, the Q&A portion has concluded. We will move to our closing remarks. Our planning committee has been working for the past 7 months on our annual WEAAD event. This slide captures our WEAAD committee. Thank you to this wonderful committee for the time and energy you all put into this event. Next, we would like to do several polls to share some facts on elder abuse. I will go ahead and launch the first poll, and we would love your participation. Please find the first poll on your screen, and I will read the question. Types of elder abuse include, and you have multiple options. I'll give you a few minutes to answer. Hey, looks like everyone has answered. I'll share the results. All right, so it looks like they're all pretty much tied, and you're all absolutely right. It really is all of the above. All of these are types of elder abuse. I'll share the next poll. The question reads, 90% of those who cause harm are family members or trusted others. True or false? I'll give you all some time to answer. Okay, it looks like everyone has answered, so I will end the poll and I will share the results. Okay, you all answered true, and you again are right. This is a national statistic from the National Association of Adult Protective Services. Great job. One last poll. Few technical issues with this poll. Give me 1 second. All right, well, we're going to skip that poll question and we're going to move into our next item. Next, I would like to introduce you to Libby Anderson, who is going to introduce our speakers.
Thank you so much, Maika, and good morning, everyone. Before I introduce our first speaker today, I would like to bring your attention to an important disclaimer. Although both of today's presenters are practicing attorneys in the state of California, no attorney-client relationship or privilege is established between our presenters and attendees of today's event, either by virtue of the content of their presentations or any questions that they may answer during today's event. Furthermore, no attendee should act or rely solely on the legal information in the presentations from today's event. It is recommended that all attendees consult an attorney licensed to practice in their state to obtain appropriate legal advice. And now we are fortunate to have a very well-known expert in the field with us today, Katherine Chu. Katherine is a staff attorney with Community Legal Aid SoCal's Seniors Unit, providing a full range of legal services to older adults in Orange County. Before joining Community Legal Aid SoCal, she managed 5 self-help conservatorship clinics in partnership with the Los Angeles Superior Court and the LA Law Library. Katherine has practiced law in both the private and public sectors. In the private sector, she has years of experience as a trial attorney representing clients in complex civil litigation and contested conservatorships cases. She has also served as court-appointed counsel for proposed conservatees. As a public interest attorney, Katherine was staff counsel for the Mountains Recreation and Conservation Authority, a joint powers authority of the state of California, providing legal counsel in its wildlife and open space acquisitions, public contracts, and agency operations. In addition to her legal practice, Katherine worked in education as the program director for real estate and legal programs at UCLA Extension, an online course developer, and an adjunct professor of law with California State Polytechnic University, Pomona. Welcome, Katherine.
Good morning, everyone. Thanks so much for participating this morning. Today, I'm going to go over the general types of conservatorships in California law, and also the primary focus is going to be on conservatorships that are governed by the probate code. One thing to understand about this area of law is that it is constantly evolving. We are trying very hard to grapple with the issues of protecting vulnerable people, but also preserving people's self-autonomy. So with that in mind, we are probably going to discuss mostly rights under the probate code, but also I'm going to cover some general new laws that are affecting conservatorships. So as you see on the screen, first, before I get started, I want to just recognize the Office of Aging, the California Department of Aging, and the County Board of Supervisors, who are always supportive of our work in the community. So thank you. Okay, so let's get started. Next slide, please. What's a conservatorship? Well, basically, it is a court proceeding where a judge is going to appoint a responsible adult called the conservator to help somebody who is vulnerable, who lacks capacity, called the conservatee. The goal of a conservatorship is really to help this person in certain areas of daily living activities, but also to protect their self-reliance and try to develop an environment which is least restrictive as far as them exercising any other rights. The standard of proof that the law provides for whether we need a conservatorship or not is clear and convincing evidence. Next slide, please. So when I like to explain what conservatorships are, I like to start out what it's not. It is not to stop somebody from making bad decisions, okay? So if you're of sound mind, but just a little crazy and you want to do a handstand in a 20-story building, if you want to live off the grid, if you want to, marry young Elvis, you can do it because it's your life, it's your choices, it's your mistakes. But the law presumes that they want everybody to have self-determination. So it's not your business if you want to do crazy stuff, if you happen to be just a wild child, okay? What it is to help somebody who's disabled.
Katherine Chu này nói về nhiều khi người già có ý muốn làm những chuyện đó.
Who may not be able to make rational decisions about their self-care and self-determination. That's really what a conservatorship is about. Okay, next slide, please. So before a court is even going to consider whether conservatorship is necessary, the court is going to ask, do you really need one? And again, the emphasis is to protect self-determination, to preserve basic civil and legal rights. And that's favored when they make a decision whether a conservatorship should be appointed. So there are alternatives that the court is going to want to look at to see if those have been tried to avoid a conservatorship. It's a severe move to take somebody's civil and legal rights away. So here on the screen are some possible alternatives to a conservatorship. You can have formal or informal help if you're disabled in some way. When my father started to have early dementia, my brother, my sister, and I, and my mother took over some of his financial responsibilities. We took care of some of his self-care. We didn't need a conservatorship, and he was fine because he understood he needed help and accepted voluntary help. Another way is joint accounts or blocked accounts if you have some issues about managing finances. When my mother had a stroke, she could not write her checks or pay her bills. So we went in, she gave me permission to have access to her funds through a joint bank account. We didn't need a conservatorship. Her bills were paid because I helped her do that. Other ways to devise property are living trusts and special needs trusts to take care of how you want your assets to be divided if you're somehow unable to do it yourself. And there are durable power of attorneys, advanced healthcare directives. These are legal documents where you appoint a trusted agent to substitute your decision-making and allow them to do it for you. You can have personal representatives to attend certain hearings. You can have authorizations where you allow somebody to have access to your medical records. Many of you may have been involved in that, where you've signed a medical authorization so somebody else can access your confidential records. That's a way to avoid a conservatorship. If you have SSI, you can elect to have a representative whose name will appear on the check, but it's your money. But they're allowed to withdraw the money and deposit it and spend it on things that you need for your care. And a new law that's coming into place that Edie later on in the program is going to dive into a little bit more is supportive decision-making. These are agreements that are written in simple terms for a disabled person, which allows that person to retain the right to make their own decisions, but they designate a team of supporters who help them gather the information, explain information, or maybe communicate what their wishes are. Next slide. Okay, so let's say none of these are available. Well, in California, guess what? Those of you who have a tattoo probably know you've got to be 18 to get a tattoo, all right? And so I like to use this slide because you also have to be 18 to get a conservatorship. Maybe they're similar, you know, a lot goes into deciding whether you want a tattoo because it's kind of permanent, and to get rid of it, it kind of involves a lot. So it's the same with a conservatorship. You've got to be 18 at least. But the thing to understand is it's not uniform from state to state. So I want to explain, sometimes you might hear guardianship, but in other states that refers to what California calls conservatorship, which is addressing somebody's needs if they're
Dạ, có nghe được chưa?
age of 18 and above.
Hello, xin trả lời. Tuy là người Việt
The
Nam thông
law
dịch
also continues to evolve statewide and worldwide. And so there's always a struggle to try to find a balance between protecting somebody's self-autonomy and also protecting somebody who really needs help. So there's a thing that I want you all to be aware of. It's called the Uniform Adult Guardianship and Protective Proceedings Jurisdictional Act. So thank God they came up with an easy acronym. Maybe we should give a gift certificate next time, and who can think of a better acronym. But at any rate, it seeks to simplify the multi-state conflicts as far as how to deal with conservatorships and how to maybe transfer one person who's conserved in one state to another and still protect them. As of January 2021, not all states have signed on to this. Most states have a modified version of this act. The only states that have not yet accepted are Florida, Kansas, Michigan, and Texas. So that's something to be aware of. We're still evolving in this area of law. Next slide. So who can be appointed? Okay, the court, it's within their discretion to act within the best interest of the disabled person. So basically, with that in mind and all things equal, they're going to use a hierarchy of who might be preferred, but it doesn't mean that they have to stick to this. This is kind of a framework that the court is going to use to decide who should be appointed. So the new law that was just revised this year first states that on top of the hierarchy is the preference of the proposed conservatee, the disabled person. And this can be expressed through speech, sign language, alternative communications, actions, facial expressions, even spoken and unspoken methods of communication. This is new to the law. Next, if that's not available, the court's going to look to maybe a prior conservator's preference. And then it proceeds to go through different relations to the disabled person, which is the spouse or domestic partner, the adult child or their nominee, parents, siblings, and then basically any other person or entity if there's nobody else in that person's life, which sometimes brings in the question of having a private fiduciary who does this professionally or the public guardian. And again, if you've got a kind of not a very good spouse who wants to be a conservator and a sibling is also petitioning, the court's going to take that into consideration and just appoint whoever they think is going to act in the best interest. Next slide, please. So there's two types of conservators you can be, okay? And it depends on the person's needs and what type of conservator you're going to ask the court to appoint you as. There's a conservator of the person and conservator of the estate. So let's take it one by one. On the screen, we have a description of what the responsibilities are of a conservator of the person. And this is because the person who's disabled needs help with their self-care, okay, their physical needs. So if you get appointed as conservator of the person, you're going to be responsible for the care, protection, and custody of that disabled person. You're going to be managing their health care, meals, clothing, personal care, possibly, housekeeping, transportation, and recreation. If you're granted the authority, you might be even given the right to basically decide whether medical treatment is appropriate or not. And if the person possibly has dementia, you might be given extra powers to maybe force the person to be in a secure memory care facility to allow the authorization of administering medication to treat dementia. And you're always going to have to report to the court of the status of the conservatorship, how things are going. They're going to check in from time to time, and you're going to have to notify the court if you intend to move or if you move the conservatee, because they want to keep track of what's going on to make sure things are going smoothly, to make sure you're doing your job as a conservator. And if you're not, to take steps to remove you to protect the disabled person. And finally, if the disabled person no longer needs a conservatorship, they have somehow regained their ability for self-determination, they're going to want to terminate it. So if you do want to move out of state, also that might be a way where it might be terminated in California. Next slide, please. The other type I mentioned is conservator of the estate. And that's when the person needs help with managing their finances. It's much more involved because if you get appointed, you're going to be responsible for managing that person's finances, taking control and locating any assets, preparing a budget, collecting income, paying taxes, responsibly investing in any assets they may have. And you're going to have to report to the court an inventory and appraisal, which lists everything the disabled person has. And then from time to time, you're going to have to come in and give an accounting, which basically you're going to have to tell the court what you did with the money, how you invested it, so they can make sure you're acting responsibly. And depending on the size of the estate, you may have to even post a bond, which acts as an insurance policy where you pay a premium and post a bond. So you're not tempted to, run off with the disabled person's money because you have access to it. So that's a kind of a check and balance thing that the court has put in to the law. Next slide, excuse me. Okay, so once you decide what type of conservator you need to be, either of the person of the estate, or you need to ask for both, then we've got to decide what kind of conservatorship you need to have. Now there's three basic types of conservatorships in California, and they're controlled by two bodies of law. The LPS, or Latterman-Petra Short Act, also known as a mental health conservatorship, is controlled mostly under the Welfare and Institutions Code. There's some overlap, but that's where you're going to find a lot of the meat of how this conservatorship works. The other two, which we're going to focus mostly on today, are probate conservatorships, which are controlled by the probate code. And there's two types, a general conservatorship and a limited conservatorship. Next slide. Let's take the first one, which we're not going to focus too much on because they're a little bit more specialized, but the Latterman-Petras-Short Act governs LPS conservatorships. The focus in this type of mental health conservatorship is to help somebody who has been deemed to have a grave mental disability, who can't manage their self-care. Maybe they're not compliant with their medication. They refuse to take it. They say they don't need it. Maybe they're a danger to themselves or others, and they need to be put in a secure facility to stabilize their condition. It often deals with people who have a psychiatric difficulty or a disability, and they need to be placed in a secure facility to have it stabilized, and so they can move forward with further treatment. Next slide. Now, the thing about this LPS conservatorship is you have to be deemed to have a grave mental disability. So what does that mean? Well, under the law, the courts have decided that grave mental disability means it's somebody who cannot provide for their basic needs like food, clothing, shelter, because they have a mental disorder, okay? So for example, it may be somebody who basically just stops eating. They don't think they need to eat. Or maybe it's somebody who's oblivious of running it on the freeway. They don't know that they have to protect themselves from harm. In this important case called Chambers, they have defined that grave mental disability excludes, go back to that first slide, any non-conforming lifestyle, any inability or refusal to take part in their own basic personal needs. It's just because they have a mental disability that prevents them from even making those decisions. So if you see somebody on the street and they're basically dumpster diving, trying to get food, they might not be considered having a grave mental disability because they know they have to have food for sustenance. So it's often a difficult thing to get to prove that a person has a grave mental disability. Next slide. So these are the types of disorders that usually are encompassed in an LPS conservatorship. You have to have a grave mental disability that's often designated in what they call the Diagnostic Statistical Manual of Mental Disorders. These are things like schizophrenia, bipolar disorder, schizoaffective disorder, clinical depression, obsessive compulsive disorder, and chronic alcoholism. These are the types of mental disabilities that are often under the umbrella of an LPS conservatorship. Next slide. So elements that are unique to an LPS conservatorship is that the court can actually give the conservator the power to force somebody to take certain types of treatment and mental health care, including psychotropic medications. The court can grant the conservator the right to force the person to be in a secured facility, like a memory care facility or a psychiatric ward. And it only lasts for 1 year because it's given the conservator a lot of power to put somebody and force somebody to do something they don't want to. What is different is to initiate this type of conservatorship is that law enforcement and medical professionals have to initiate the process. And there are things like a Reese hearing where if the person refuses to take medication, they have to have a hearing where the person's rights are going to be considered, whether they're forced to take the medication. And also what's called a habeas corpus hearing, where they can challenge the right to be held involuntarily. Next slide. And just briefly, the way the process works, if you think a LPS conservatorship is important, is that there has to be first an evaluation from a PET team or law enforcement. Then an authorized psychologist will evaluate the person. And if they think that an LPS conservatorship is appropriate, they'll contact the public guardian who will initiate the petitioning process. If you're a family member, you can work with the public guardian asked to be appointed as the LPS conservator. Okay, next slide. So now let's get into the meat of the probate conservatorships. Basically, the first one I'm going to talk about is a probate limited conservatorship, and that has to do with somebody who's developmentally disabled. A developmental disability originates before the age of 18. It may continue indefinitely, and it really constitutes a substantial disability or handicap for somebody to do daily living activities. It's often somebody with autism, cerebral palsy, intellectual disability, or Down syndrome or epilepsy. And it includes conditions that are associated with intellectual delay, but it cannot be just physical disability. It has to be associated with some sort of mental incapacity. The focus in limited conservatorships is to say, we want this person to have as much maximum self-reliance as possible and just take some civil and legal rights away from them in areas where they need help with. These areas that can often be associated and asked for as far as a conservator's power is to decide where they're going to live, have access to their confidential records, make decisions about their medical care, to decide whether they might enter a marriage or domestic partnership, and to make decisions about their education, sexual, and social contacts. And if they have only SSI, you usually don't need to be a conservator of the estate. You just become the rep payee. Next slide. Important in a limited conservatorship is the role of a regional center. These are statewide community-based nonprofit agencies that really provide services to developmentally disabled people. And they're going to do an assessment whether there's a substantial disability exists in this person requiring services. And if 3 or more of these major life activities exist, then you may be appropriate to seek a limited conservator. And these areas of life activities are self-care, receptive and expressive language, learning, mobility, self-direction, capacity for independent living, and economic self-sufficiency. Next slide. The other type of probate conservatorship is a probate general conservatorship, and this usually applies to just an adult who may need a higher level of care. You often see this in elderly people, maybe people who have dementia. But it can apply to younger people. I mean, if you or I suddenly get in an accident, we're in a coma, somebody might step in and file for a general conservator because we're an adult and we need a higher level of care. The responsibility of a general conservator is the care, custody, and control of that person to help them on the road, hopefully, to recovery. Next slide. So the major differences are this. A limited conservator is for somebody who's developmentally disabled. The conservator is encouraged to have have the disabled person have self-reliance, to develop, to be as independent as possible. You can ask for 7 of those powers when you're appointed. And there's more restrictions on the conservator as opposed to the conservatee, because they want the person to have as much self-autonomy as possible. And it usually terminates upon the death or resignation of a conservator. A general conservatorship, on the other hand, gives you much broader powers. You don't need a regional center. And also, unless the court has specifically taken that power away by court order or statute, you usually retain as many rights as you can. But practically speaking, if you're under a general conservatorship because of your disability, you can't really exercise a lot of those rights. And then on death or resignation of the conservator, the court can appoint somebody to fill the vacancy. And you can also request special dementia powers to put the person in a locked facility and force them to take medication. Next slide. The thing about dementia powers is that these are special powers that have to be requested if you petition for a general conservatorship. And that's because, like the LPS conservatorship, it's giving you a lot of authority to force somebody to do something they don't want to do and maybe authorize medication that they don't want. And this is unique to a general conservatorship if you want to ask for those special dementia powers. Next slide. How does the court do it? Well, they ask when you petition to submit what's called a capacity declaration. It is a form that the petitioner will take to the doctor of the disabled person and have the doctor fill it out. It basically can be filled out by a licensed California doctor, a licensed psychologist, or a healing practitioner if they're registered with the state. It provides information about the conservative's mental and physical capabilities and their diagnosis. And it seeks a medical opinion as to whether they can attend the hearing, whether they can consent to medical treatment and have that capacity. They want to also know if the person has a major neurocognitive disorder, allowing for dementia powers. And both the Los Angeles Superior Court and the Orange County Superior Court are going to require that a capacity declaration be submitted with every petition, whoever wants to be a conservator. Next slide. So why would we want a healthcare professional to even step in to make a decision about capacity? So we're going to take a little detour about capacity, but basically it's to document that you have actually done some cognitive testing to justify a conservatorship. It may also help you clarify the existence or magnitude of how serious the mental deficits are. It may help to link mental functioning with certain activities or decisions. And it also helps with determining whether there's undue influence in certain cases. The court may also want to know how we can link certain types of behavior with certain types of acts. In dementia, sometimes early dementia cases, somebody might have complete apparent, well-mannered social behavior, and yet they're making some irrational decisions otherwise. So a lot of times a capacity declaration or assessment by a healthcare professional will help us figure that out. Why are they doing this when they used to not do this before? Okay. And it also helps to decide whether maybe medications is just a temporary thing on their capacity. So maybe we don't need a conservatorship. And what's really important oftentimes for people who are practicing in this area as lawyers is to really find out the client's capacity to even hire them. And, you know, a lot of these cases come up with undue influence. If somebody younger comes in with an older person and the older person says, I'm going to change my trust and give everything away to this caregiver, that kind of thing. Next slide. So the law has always grappled with this problem with capacity. Common law is the type of law that's develops over time through case law, not statutes, not codes. And this is an often still accurate case. It's 1948, but it basically echoes what I said in the beginning. It's been held over and over the state that if you're old, if you're feeble, if you're forgetful, if you have filthy personal habits, you're eccentric, okay? Or you fail to recognize friends or have a physical disability, you're absent-minded, you're mentally confused. Well, guess what? You still have the right for testamentary capacity, meaning you can give away your stuff to whoever you want, and the law is not going to interfere. That's kind of where the law was going with case law. Next slide, please. So over the years, we have eventually codified some of the decisions about legal capacity. And right now, the Court of Appeal has said that determining a person's mental capacity is basically fact specific. All right. So a person's capacity to comprehend a certain document is going to depend on how sophisticated and how complicated that document is. So it's a sliding scale on whether a court's going to decide this person has mental capacity or not. On the high end is if it's a contract. A contract can be difficult to understand. It has, complicated terms. And so in a contract case, they may have a different standard for whether the person really understood what they were signing. The middle range is for testamentary capacity, depends on how complicated the document is when they signed off. And the court, again, is going to consider the facts. And on the lower, what's interesting is on the lowest end of the scale is if you've got the capacity to marry or execute a will, we're going to leave you alone. You do what you want to give away your stuff when you're about to die, and we'll leave you alone if you want to marry. I always like to think about that famous quote that says, love is temporary insanity cured only by marriage. Okay, that'll sober somebody up, right? Once you get married. But that's the lower end of legal capacity right now, as it's stated in the courts. Okay, next slide. So the court, when it has an undue influence case before it, is going to really decide if it exists by looking at the facts. Undue influence is defined as excessive persuasion that causes a person to act or refrain from acting because somebody has tried to overcome their free will, and it results in some sort of inequity. So the four types of things that the court's going to look at to decide whether somebody's been undue influenced in their activities is vulnerability, the influencer's authority, are they a caregiver, are they a family member, actions of the influencer, and the equity of the result. So a lot of this is fact specific again. Next slide. The appointment process can be long. It can be several months, but basically what happens is when somebody wants to be a conservator, they're going to file a petition. They're going to mail it to relatives of the first and second degree. A probate investigator is going to be assigned to come out and meet with the proposed conservatee to see if they understand what's going on. Also meet with other people who are involved in the conservatee's life and also the petitioner. They're going to assign an attorney to represent the disabled person, either the public defender in Orange County or a court-appointed counsel in Los Angeles County. And they are there to represent the conservatee in what's really an adversarial proceeding. A limited conservatorship, again, will require a regional center report. They're going to have a hearing. If it's contested, you may even go to trial. And then you have to file some post-hearing documents to actually get the official document, which is called the letters of conservatorship. And after you get appointed, the court now has jurisdiction over the case, meaning they're going to continue to monitor you as the conservator, and they're going to send out a probate investigator probably the first year you've been appointed, maybe every 2 years, to check on you, to see if things are going smoothly, to see if you're doing your job as an appointed conservator, to see if the conservatee has progressed enough where they don't need a conservatorship and they give that person their rights back. Next slide. So how does it end? In a probate conservatorship, there are several ways it can end. You know, obviously, if you're a conservator of the estate and there's no more money, they may end it, okay? If the conservatee regains capacity, they come out of a coma, the court may say, let's stop it. We don't want a conservatorship unless it's necessary. If the conservatee dies, obviously, it's only to help somebody while they're alive. The court may remove the conservator if they're not doing their job, they're doing some abusive behavior. They may end it that way. If the conservator dies in a limited conservatorship, you can resign. You don't have to be the conservator forever if it's too much, and sometimes that happens. And if they're granted permission to leave out of California and go to another state, the court will terminate the conservatorship here they will have a hearing to find out what's going to go on with this disabled person. If you're moving out of the state, are they going to be protected there? And then now in the newest law under AB 1194, which we're going to briefly go over, is that there has to be clear and convincing evidence. It still needs to be in place. That's where the pendulum is swinging now, that we want to terminate it as soon as we can. We don't want to keep it in place unless it's absolutely necessary. Okay, next slide. And then a conservatee will always have rights. So you need to know that even though a person's conserved, they still have certain rights. Next slide. And these are the rights. They can be represented by a lawyer, ask the judge to replace the conservator if necessary, ask the judge to end the conservatorship, receive a salary if that's not been taken away, or make or change a will. If the court has not curtailed these rights, the person still has a right to receive personal mail, to vote, to marry, or enter a domestic partnership, make their own medical decisions, and basically do any type of transaction or activity that the court has not taken away. So just because you're conserved doesn't mean all your rights are given away. It's just to help you in certain areas. Next slide. So what's on the horizon? AB 1194 was just enacted as of 2022 in January, and it has much more scrutiny on professional fiduciaries. They have to post their fees on the websites. They're going to have more opportunity to investigate abuses, remove their licenses if they shouldn't be fiduciaries. Court investigations are going to have a broader responsibility, and they want to terminate it after 1 year if it's not needed. And any interested person can petition the court if they suspect abuse. There's enhanced sanctions where a professional fiduciary might end up paying sanctions of up to $10,000, a lay person $1,000. And a court-appointed counsel must be assigned to a disabled person who's a subject of conservatorship, and they can choose whoever they want if that person can provide what they call zealous advocacy. And you can terminate the conservatorship if there's clear and convincing evidence, so they're going to constantly evaluate it. But the big caveat in this new law is that the legislature must have appropriate appropriations for this, and it's not there yet. So this is, I say it's on the horizon because we're not quite there with the funding. Okay, next slide. So we're going to take a real poll here as to what zealous advocacy means, and I'll just let you all handle it. So in 2020, the total, oh, this is a different one. Okay, so this is the other poll. Mine is zealous advocacy. Sorry, gang. We've got them a little mixed up. Okay, here we go. So AB 1194 requires that a court-appointed counsel represent the disabled person with zealous advocacy. If the proposed conservatee tells counsel they don't want to be conserved, does that mean that the attorney if they believe that their client's going to benefit from a conservatorship because they might have diminished capacity, does that mean zealous capacity? Which one do you think? First, if it means that council vigorously assert that they don't want a conservatorship, whether they believe they need one or not, or second, if acting in their best interest, they don't advocate for it to not go forward. Everybody vote really quickly. We have only a few more minutes. Okay. Results. All right, zealous advocacy means you have to vigorously advocate, and most people chose B. Okay, so let's close that and go to the next slide. And I'll tell you what the court says. Next slide. There we go. This is what the court says in its new law. The court-appointed counsel shall be a zealous, independent advocate representing the wishes of their client. So the conservatee and any persons alleged to lack legal capacity are ordered to have their own protection as a lawyer who's supposed to fight against any deprivation of their rights, including objecting to a conservatorship. They removed language that the attorney is supposed to act in their client's interest. So they can't use their own opinion, whether they think a conservatorship is appropriate or not. If the conservatee says, I don't want a conservatorship, even if you think they've got diminished capacity, that's your job as the attorney. The hope is that the system will work and will turn out any facts that say one's necessary. Next slide. So here's another law that you all have heard in the news. It's SB 1338. It's a care court. And this is basically more associated with the LPS conservatorships. It's for people who are severely untreated with mental disabilities like psychotic disorders. And the whole idea of this law is to bridge the gap, because a lot of these people, when it goes untreated, just remain homeless, or they get incarcerated, or they get committed. So the idea of the care court is to have this diversionary program where they're going to get the person, make them be, which is why it's controversial, participate in a medical plan, a care plan for 1 year, and it can be extended for another year. And if they still don't get through it and get stabilized, then maybe the court will consider they're appropriate for an LPS conservatorship. So 7 counties now are supposed to start implementing this new law, which is supposed to be in effect as of September 2022. The counties that are supposed to implement it by October of this year are Glen, Orange, Riverside, San Diego, Stanislaus, Tuolumne, and San Francisco. The remaining counties in LA are going to have this in effect in December of 2024. Next slide. And finally, what Edie is going to talk about is AB 1663, which is the Probate Conservatorship Reform and Supported Decision-Making Act. It amended the probate code, which allows for maybe a disabled person to have an agreement, to have a group of supporters who will help them gather information, but they still make their own decision. It's not a substitute person who helps them. It's they make their own decisions and retain their right and empowers their self-autonomy. Basically, the Superior Court is ordered to develop self-help centers to educate the public on this. And they also have to provide the conservatee with information about their rights, who the investigators are, and that kind of thing. But Edie's going to get into a little bit more detail. Next slide. And this finally brings us to our, full circle. The court does not want a conservatorship unless it's necessary. And the first question they're going to ask is, please use an alternative route. Do something else. So the court is going to ask any petitioner, have you considered alternatives? Have you explained why alternatives are not suitable? Have you described what you tried? Have you provided details about how long you tried these alternatives before you gave up and tried to come to us to do a conservatorship? And have you given reasons why they don't meet their needs? So this is the whole area where the law is now evolving, saying, let's try to retain somebody's self-autonomy and not do a conservatorship unless it's absolutely necessary. Okay, next slide. And this is my contact information, and we can open up for questions.
Hi, Kathy. So this is Laura Liu, and I'm looking at the questions. And the first question that was posed is, what does it mean for a conservator to resign? Does it always lead to replacement?
Does it always, as you broke out to replacement? Okay.
Yes, does it always lead to a replacement?
No, it does not. I mean, and that's where the law is going now, is that they want to terminate it and the conservator wants to resign. The court has already made a determination legally that the person is disabled and needs help. So if a person resigns, the court may say, okay, is there anyone else who's going to step in to replace this? Public guardian step in, they're with the Department of Mental Health to fill that gap. But of course, if it depends on the facts, if the conservator is resigning because the person seems to be fine, they're going to go with the decision, let's just terminate the whole thing, because they do not want a conservatorship. As you all have heard, you know, in the news with the Britney Spears case, the pendulum is swinging to say, let's not do a conservatorship unless it's necessary. Okay, next question.
Okay, the next question is, should a spouse apply for the conservatorship?
Well, that just depends on if the person is willing to take on that responsibility. And it depends on the type of conservatorship too. You know, there are some limited conservators who might be married as well. But you're one of the people who is allowed to petition. It just depends on how much your responsibility you want to take on. A lot of times spouses do it because they've been taking care of their spouse anyway for many times, for many years. And as they've progressed maybe in dementia and that kind of thing. You need to understand that even though the person has lacks capacity, that just because you're the spouse, you cannot automatically sign off on things when it comes to you know, their legal rights. So that brings in the question, is there a power of attorney? Is there an advanced health care directive? Because just because your spouse does not give you the legal right to sign off on things because your spouse is no longer capacitated. So you very well may need to do a conservatorship if you've not had any of those planning documents in advance. Next question.
All right, so I don't think this question was answered. So I'm going to ask it again. Are there checks and balances that review personal relationships between the person declaring and the health professional who signs the declaration?
Are there checks and balances between the person petitioning? Can you read that again, Laura?
Well, it was the person declaring. I don't know what that, and the health professional that's signing the, I'm assuming, capacity declaration.
Oh, okay. Well, a capacity declaration is a declaration for the attorney. I mean, the doctor to sign, verifying this is their medical assessment. Maybe you meant the petitioner. Are there checks and balances between them? Not really at this point. If you petition, you go to the doctor of the disabled person and get them to sign a capacity declaration. I have been in cases with contested conservatorships where you know, the petitioner provided capacity declaration, but because I was representing the conservatee, it was my job to be their advocate, and they didn't want a conservatorship. And I did more research and found out the doctor who signed this capacity declaration, you know, was never her doctor, and she never gave permission for him to look at her medical records. So I went out and got another capacity declaration from a doctor she wanted and who she treated with. And it became something for the court to decide. So it is fact specific. Sometimes you have, in contested cases, dueling capacity declarations, and then oftentimes that's going to end up in trial, like any other case, where they're going to have a battle of the experts. Who's the more credible and authorized person to speak about this person's disability?
Okay, so the
Any
next
questions?
question, yes, the next question is, what can a family member or friend of the conservatee do if they suspect the accounting is not accurate?
You can now, under this new law, petition the court for abuse. Okay, so under 1194, you can, you are now entitled, any person can do it who's interested, file a petition with the court and say, I suspect there's abuse with the conservator of the estate, and get it before the court, and has to be done by a motion.
So there's a question that says, can the family of the conservatee request an accounting outside the once a year requirement if there is a suspicion the conservator has not been honest in managing the conservatee's money and or assets. And so they're basically asking if you could do an extra accounting. And how would they ask for this?
Like I said in the previous question, you can petition the court. A lot of times the first step is to talk to the investigator. So you contact, I usually tell people, contact the probate investigator first, because they can do more investigation. They're ordered to do it, to find more if they suspect abuse. And they can also request a hearing before the court, but you can also petition the court. You get the case number, you file a petition and indicate. Now, as I said, under AB 1194 is a new law that says any interested person can petition the court for review if there's abuse. And you can order another accounting or request another accounting, but it's the court that actually orders it. So you do, the court sets its own calendar as far as how many accountings and when the next accounting is due. But you can always, if you're an interested party, raise questions with the court that you think it's not correct. And once you get, but you have to do it by a petition.
Okay, so we have a question is, when it was said that there were two types of conservatorships, a person and of a estate, were those two types of probate conservatorships?
Yes, but you can also have a LPS conservatorship of the person and conservatorship of the estate. It's what the disabled person needs. If they need help with their physical needs, it's conservator of the person. If they need help with their finances, it's conservator of the estate. If they need both, you can apply for both. And it's you can have one under an LPS conservatorship and also under the probate conservatorship. I've seen it even, which is rare, where somebody is under an LPS conservatorship, but the family member files for a conservatorship over the estate under the probate code, because it doesn't have to do with, their money or anything it doesn't have to do with their medical care. It has to do with managing their money. That can get a little difficult because you're supposed to work together. If there's two people who are conservator of the person, conservator of the estate, you're supposed to work together for the care of the disabled person. But, you can be a conservator of the person and a conservator of the estate, either in an LPS conservatorship or a probate conservatorship. It's what the person needs help with. It's what type of conservator is going to be appointed.
Okay, so the next question is, what happens when the conservator resigns because the estate has run out of money?
The court is going to terminate the conservatorship. If it's a conservator of the estate, okay? If there's a conservatorship of the person and a conservatorship of the estate, and there's no more money for the conservator of the estate to manage, they'll dismiss that, but they may keep the conservatorship of the person in place because the person still is disabled and can't take care of their physical needs. So the only reason you have a conservator of the estate is you're the responsible for managing money. If there's no money, no more assets to manage, they'll terminate it. They don't want a conservatorship unless it's necessary. They want to give everybody their rights back, if possible.
Okay, so the last question we have is, can you please comment on how much all of this may cost you if you have to hire an attorney? Or is there any free, I'm going to add to it, or is there any free legal help out there?
There is free legal help. There are some, especially us, sometimes we can help, but you have to qualify for eligibility under our grant purposes. So, we encourage you, if you want to call a hotline, to see if you do. But other than going through legal aid, if you go through a private attorney, it depends on the county, depends on the firm you pick. If it's a boutique firm, it's a little mom and pop firm, but it can range sometimes from maybe I've seen it from between $3,500 to up to $10,000. Just depends, so you're going to have to search if you're going to go through the Orange County bar or a private attorney, and like shopping around for anybody else to see if you're comfortable with them. The expense can vary, but it also depends on the case. If you've got a battling family, you might have several hearings, and that can get expensive because you file a petition, somebody's going to oppose it. And so you have hearing after hearing, and then it gets very, very expensive. And some people do it themselves. You can get the documents for petitioning online through the court self-help center. Sometimes that's available, but we recommend that only if it's a real straightforward case. Nobody's going to fight. And it is a lot of documentation involved in a lot, so it can get a little bit gnarly if you're completely not used to this kind of thing. But, you know, we encourage you to call community legal aid because you could qualify for our services, but it just depends. You know, we can't promise that we can represent everybody because we do have certain grant requirements that we have to meet. Otherwise, we would probably recommend that you go to the Orange County Bar or consider self-help at the self-help center.
Okay, so one last question that popped in. What happens when a conservator themselves is now in a conservatorship?
Well, that's very interesting because I would wonder how they got into a conservatorship if the court didn't sort that out. But if a conservator has lost their capacity and they're subject to conservatorship, then, you know, the court is going to probably try to sort that out. I mean, if nobody knows about it, then maybe an interested party is going to have to let the court know. But that's kind of a very unusual set of facts on how it could get that far for somebody to petition for conservatorship over a conservator. But again, they're going to make a determination of capacity if that conservator no longer has capacity to manage their own life, let alone somebody else's. They're going to remove that conservator. Maybe it depends on the kind of conservatorship. If it's a limited conservator, they're going to terminate the limited conservatorship. And they're probably going to set a hearing and find out if it's necessary to fill the vacancy, to terminate it, to appoint the public guardian, or if a family member steps in, or some other interested party steps in, and whether they should be appointed to the original conservatee. Okay. Anybody else?
No other questions.
Okay. All right. Thank you so much, everybody, for listening. I'm going to turn it back over to our staff. Okay, thanks.
Thank you so much, Katherine.
Yes, thank you, Katherine. And we are so fortunate to have another well-known expert with us today, Edie Mermerlstein. Edie is the owner and founding attorney of FEM Law Group with offices in Orange and Los Angeles counties. While her civil practice is quite broad in scope, she has special interests in financial elder abuse, trust and estate litigation, and women's issues. Edie is a graduate of USC's Marshall School of Business and enjoyed a successful career as a financial analyst and tax professional before pursuing a legal career. She obtained her Juris Doctorate and has been a member of the California State Bar since 2007. She dedicates a percentage of her practice to pro bono work to reach the underserved and is committed to the pursuit of justice. She is also a consulting member of Orange County's Financial Abuse Specialist Team, or FAST, and her career highlights include, in 2008, she established pro bono legal program to serve women battling breast cancer. In 2014, she was the Consumer Attorney of California's Street Fighter of the Year finalist. In 2015, she made appearances before the U.S. Supreme Court on behalf of California consumers. And from 2016 through 2022, she's a super lawyer's she's been considered a super lawyer, and so do we. So thank you so much and welcome, Edie.
Thank you so much. Hi. I'm so glad. I just want to first thank Katherine Chu. It was a great presentation, and a lot of the stuff I'm going to be covering may overlap. So I may scoot through some of the slides that are really dealing with the conservatorship process. My presentation today is about avoiding conservatorships and then uncovering financial abuse and what kind of legal action you can take. Next slide. The first thing you need to understand is capacity and decision making. Now, the definition of capacity is the ability to understand, make, and communicate decisions. Capacity is presumed in California. So there has to be some kind of legal underpinning to make somebody incapacitated under the law. Now, there's a lot of relevant statutes that we look at. Capacity means a person's ability to understand the nature and consequences of a decision and to make and communicate a decision. And it includes, in the case of proposed healthcare, the ability to understand the significant benefits, risk, and alternatives. If you don't have that level of understanding, you may lack capacity. Like I said, there's a presumption that everybody has capacity. So from the get-go, we have elders right now that may lack capacity, but it hasn't been uncovered. And there's a lot of issues when you don't have capacity and predators are out there swimming in the water, making phone calls, and capacity hasn't been taken away. Well, it's not taken away, but the ability to understand what's going on may get more and more difficult for our elders. And that's where we come in to try and protect the elders and understand what their capacity and decision-making is. Now, as you heard from the last presenter, talking about, crazy decisions and wanting to do things that are kind of not part of your personality, that may indicate some kind of cognitive decline that is starting because of the aging process. That's where it starts becoming a slippery slope, and capacity becomes more and more important to establish and/or establish incapacity. Next slide. So, like I said, it's a rebuttable presumption. There's a spectrum. So sometimes, we'll hear people say, oh, it's just my memory. It's just an age thing. There could be a complete loss of capacity, but that's pretty rare. But, if you're in a coma, obviously you've lost complete capacity. And if you don't have any documents, which we'll talk about the documents later in the presentation, at that point, you very well may need a conservatorship. Now, the assessments that happen might not always reflect the elder's true level of capacity. And like I said, there's non-permanent capacity issues. Somebody may have had a stroke and they find themselves in the hospital and they're put on different kind of medications and there's illnesses. All of a sudden they wake up and they're in an assisted living. And during that period of time, certainly they had lost capacity to handle their own finances, and somebody's having to feed them and make sure their activities of daily life or their ADLs are being taken care of. Now, there's also interesting issues with capacity and elders where there could be sundowning. And when sundowning occurs, an elder may be fresher and more attentive in the morning. And then as it gets later in the day, the capacity starts waning. So there is this whole spectrum of capacity. But again, it's a rebuttable presumption. So initially, everybody is presumed to have capacity to make decisions. However, that capacity can be rebutted, and undue influence is another really huge issue with vulnerable elders that we're going to be looking at as well. Next slide. As you heard with Katherine's presentation, there has to be a judicial determination of incapacity that's typically done in a conservatorship proceeding. A conservatorship proceeding or possibly some kind of criminal or other civil type of proceeding, but before a court. So the judicial determination is going to look at deficits in the mental functions, and it's not just, oh, they have Alzheimer's or, oh, they have dementia. Just the mere diagnosis of a disorder does not necessarily mean that the person is incapacitated in every area of their person. Again, we heard from Katherine that conservatorship proceeding can be commenced now by a concerned relative, a friend, an interested person, a neighbor. Somebody might see something going wrong and know that there needs to be a conservatorship. The proposed conservatee is always going to be appointed representation by the court, and there will be a probate investigator. And evidence of incapacity is going to be presented in contested matters. If you come upon a person who truly needs a conservatorship, they have no other documents in place, there's no other alternatives of least restrictive means to help this person who doesn't have capacity, then that's when you could get siblings against a step parent or siblings against siblings. It takes on all kinds of forms. These contested cases can take up to 18 months or longer to be heard. During that period of time, the court may appoint a temporary conservator if there are no other alternative means that are in place that are not tainted in any way. So, for example, you may have a caregiver who has obtained a power of attorney, and now an interested party or a family member has found that, oh, this looks like this person needs a conservatorship. Maybe some things seem nefarious in that the conservator, the proposed conservatee is being kept from family members, or there's a cloak of secrecy on the finances, or the family starts noticing strange purchases and things like that. They may need to go in and do the judicial counsel forms, which you can get online, and then there's self-help to start the conservatorship proceeding. And this may be uncontested or it may be contested. If it is contested, I'm seeing up to 18 months or longer for it to get to trial. Next slide. So we're looking also at mental functions and deficits, and it has to be in at least one area. So this is for judicial determination. They're going to look at alertness, and that's going to be, excuse me, the level of arousal or consciousness, orientation to time, place, the situation, the ability to attend and concentrate. So that's alertness. Attention is both the short-term and long-term, and including immediate recall. It's also the ability to understand and communicate with others, verbally or otherwise, recognition of familiar objects and familiar people. I've heard before that there is a slight difference where if you're simply losing your memory, you might forget where your keys are. So you're like, I don't know where my keys are. I don't know, and that might be, something that's triggering some mental cognitive decline. But if you literally don't know what keys are, that is a whole different level of processing that could be off. And that could be more Alzheimer related. And so there's a lot of different functions in here. The thought processes, if there's hallucinations, when people just don't understand who the family is or what their possessions are, that's when you know there's some severe issues with capacity and that there's some deficits in the mental functioning. Now, it has to be, when there's a contested conservatorship, there has to be some type of true determination there. And that's where a lot of times these conservatorships that are contested can get very expensive. So I know one of the questions previously was, how much does it all cost? If it's a non-contested conservatorship, straightforward, that is going to be different. I have seen contested conservatorships get into the six figures if you're hiring, different psychiatrists that are going to be looking at the mental functions and deficits and mood modulation and thought processes. Okay, next slide. So also in the mental function deficits, it doesn't just need to be there's a deficit in one. You also have to show the frequency, the severity, and the duration, and how it impacts the specific type of decision that you are trying to get conservatorship over. Next slide. So again, I just want to say it over. Just because someone has been diagnosed with dementia or early onset Alzheimer's or some other type of mental disorder or a physical disorder where it may affect their ability to communicate, they may have locked-in syndrome and not be able to outwardly communicate because of a stroke or other physical disorders. And that's not sufficient in and of itself to support a court to determine that that person has an unsound mind or lacks capacity. So again, there's the least restrictive means that we're going to look at. And conservatorships, since January 1st has been enacted, all of these rules and laws, it appears that they are disfavored. I also know that over the last 10 to 15 years, there has been severe court funding shortages, which makes the courts, especially a probate court, which is a court of equity, that I attend these hearings on a regular basis, and there may be 35 to 50 cases on calendar for check-in for some kind of case status, and the judge has about 3 hours to handle those 55 to 60 cases. So that would mean each case only got 3 minutes. And we all know that's not, it's one of the things that we need more judges. So I don't want to get on a soapbox on court funding, but I do believe that plays into this conservatorship being disfavored because there isn't really truly enough funding to handle it. So appropriations is also something that the new laws are going to require, meaning money has to come in to fund the probate investigators to go out. And so they're really looking at other means to kind of calm the wave of conservatorships, because there's also another compounding issue. Baby boomers, the youngest baby boomers as of today are 59 years old. That means in an elder abuse capacity issue, when you're doing an elder abuse case, 60 is when you're considered an elder. So there is a huge boom of elders now that are even in their 80s and 90s that we're seeing may or may not have capacity. And then you have predators out there that are all the more willing to take advantage of these elders. Next slide. So we're going to look at least restrictive alternatives and supports. The conservatorship should be the least restrictive. So we're not going to look at that. We're going to go on and look at possible other supports. The big one I want to talk about today is a supported decision-making agreement, which just came into law. They're still developing it as far as having like a form online for anybody to download, but I'm going to go over a couple of issues with that. But just beyond that, everybody, no matter how old you are, and preferably before you ever get to a stage where you're incapacitated, should have a power of attorney for finance, have an advanced healthcare directive. If you are sick and you know that you're going to be having surgery, making sure you have the appropriate healthcare surrogates and people that can answer questions for the doctors, and that everybody has the appropriate powers going in. If you have those base documents, you may be able to skip over a conservatorship altogether because a hospital will recognize an advanced healthcare directive. The bank may recognize the power of attorney with documents saying that the person, 2 documents from 2 physicians saying that the person can no longer make financial decisions for themselves. Banks are getting a little more picky on the power of attorney documents. So I've seen a lot of problems with that. There is, however, in the code, if you have executed a durable power of attorney, and it's a uniform statutory durable power of attorney, that document, a bank cannot refuse to honor it unless they have some big red flag suspicion, or they can't just say, we have our own form. We're not going to accept this form for your mother or your father or whatever elder, and you happen to be the power of attorney. So it's important to know what the rights are and how to work with financial institutions. Next slide. So supporters, so with the supportive decision-making documents, which I'm going to get into, the supporters are going to be bound, much like the court-appointed counsel for a proposed conservatee. You need to have obligations to protect the vulnerable adult from mistreatment, physical and financial abuse, and you have to have the vulnerable elder's decision, values, and preferences at the forefront. So again, the supported decision-making agreement is really going to be to allow the vulnerable elder to make their own decisions and have an advocate outwardly enforcing them. Next slide. Oh, we're going to have a poll right now. So the poll has to do with supportive decision-making. Have you ever heard of supported decision-making agreement prior to me just explaining it or noticing it? Okay. So 21%, 79% haven't. So that gives me a good idea of what kind of audience we have here. So I am going to really give you some tools to try and dive into the supported decision-making agreement because it could be really helpful. Next slide. Okay, out of the 21% that have heard of it, do you have a supported decision-making agreement or know someone that does? And then of course, if you don't even know anything about it, then you could go ahead and answer no. Okay, 1 out of 90. So that's good that somebody has one. That's great. Next slide. So the supported decision-making agreement, SDMA, SDM, it's called a couple different things. One of the documents that that is online that you can get, it is from the ACLU Disability Rights Program, and they have a pretty decent supported decision-making agreement online for use. And so next slide. So first of all, the benefits of this decision-making agreement. It basically can help with cognitive decline. Once somebody's starting to slip, but they still have a level of knowledge and they know what their decisions and who they want to help them. It's great because you could get this without court involvement, similar to a power of attorney or an advanced healthcare directive. It's a little different because it's in really simple language. The biggest thing that I see with this document, though, and with our vulnerable population, is that there may be no supporters that the vulnerable elder has in their life. And this is what we really have to figure out as a community, because this is what I'm seeing more and more. So, for example, one of the things that the supporter can look at is personal care. So it breaks everything down, making choices about food, about clothing, and the elder or the vulnerable person can make decisions. I mean, even people prior to ever becoming incapacitated can take a look at this document and you could fill it out yourself and say, hey, if I wound up in a terrible position tomorrow, who do I want to make choices about where I live and who I live with? And you can put different supporters for different areas of your life, like food and making decisions if you could marry or not, making decisions about money, all of these things. And then you need to make sure that you sign it and your supporter signs it, and it can be read aloud. So one of the great things is a power of attorney is usually a document that requires a higher level of capacity. If the SDMAs really, not that they have a lower level, but they're so simple that if a person can really attend and make these decisions, then you can put them down. And it just needs to be witnessed by 2 people and or notarized. Next slide. So you really do have to get supporters, and then they can be present at doctor's appointments. They can go with you to any kind of, to the bank. They can go with you to deal with, help you coordinate how you're going to get groceries. Let's say, you have a really good supporter and this document has been fulfilled. It's supposed to supplant the need for conservatorship so that somebody can get in there and really help the person that has the cognitive decline and just to be able to continue living independently. And let me see, it can terminate upon obviously if the vulnerable adult passes away, or if a conservatorship is found. At that point, the supportive decision-making agreement goes away and is replaced with the conservatorship. Next slide. So there's a couple differences I alluded to previously. So the supportive decision-making agreement, it's not a contract, it's an authorization. So that's why it's so much easier to understand. And again, it's going to be up to the vulnerable elder to decide who's going to support them in making their own decisions. So they want to pick people that are going to fulfill their own decisions and not kind of move along and do things that they think, like the caregiver thinks are appropriate instead of what the person wants. This will be considered a least restrictive means. So if a conservatorship has to be filed, one of the things is you can always put down that one of the least restrictive means was we tried a supportive decision-making agreement, and at this point in time, it no longer operates properly because the capacity has delved into incapacity. Now, getting a power of attorney, that's a complex document. I already told you it's going to have a higher level of understanding, and it may be harder to execute. You can't execute a power of attorney if somebody's lost capacity. If somebody is truly incapacitated, it is not ethical to have a power of attorney signed, and I've seen far too many abuses of this document being used to financially elder abuse. And so that might have to be when a conservator steps in place. Also, a power of attorney and an advanced healthcare directive, a power of attorney will go away in the instance of a conservatorship of the estate, and an advanced healthcare directive will also terminate when a conservator of the person is found. Next slide. So now I'm going to talk a little bit about uncovering financial abuse. Next slide. We see the signs. I'm seeing them. You know, I'm sad to say that my office has never been busier with financial elder abuse. There's improper transfers of assets. There's the funds being missing. There's, you know, fraud. A lot of the things that we have to worry about is, you know, we've all heard somebody calls there now with AI, and I don't even like to get into this too much, but fraudsters are getting so sophisticated that they can literally have a voice call that sounds like a person that say, you know, they call somebody and say, "This is your grandson. I need help. I need you to Western Union or mail me, or, you know, whatever, an amount, $3,000. And the vulnerable elder is so convinced that this is truly a person that's in their life that they go ahead and they click, and then boom, it's gone. I've seen some disasters happen lately. Also, in one of our FAST presentations, we had the FBI come out and they were talking about real estate fraud, and 50% of all real estate fraud in the United States is happening in Southern California, which is a staggering number. And one of the things I see are deed transfers, whether it's to a caregiver or, you know, all of a sudden somebody signs off, and it's getting pretty aggressive. So the biggest thing for our community is if you have vulnerable elders in your life, you need to be looking out for unusual financial transactions. If somebody calls, I gotta tell you, somebody called one of my parents, my mom, and said, and my mom called me and she said, you know, there's somebody called me and they want to come over and review my trust, and they want to come to the house. I'm like, was it your trust attorney? No. Okay, well, why would somebody come to your house and want to review a document? So people are so tricky now, and it's getting, you know, all of a sudden assets are disappearing, valuables are disappearing. If you see isolation in your family, if all of a sudden you see restricted access to financial information, that is a red flag. And of course, if there's anything unpaid, the property tax goes awry, that kind of thing. Next slide. So I want to talk about reporting financial abuse. Of course, there are mandated reporters of financial abuse. The steps really to report it, you want to immediately document and get any evidence. Early preservation of evidence is going to help with any future legal actions. Contacting law enforcement, contacting APS, get as many details, information, dates, and then cooperate with the ongoing investigation. Again, we have lack of funding in law enforcement, so it's very hard to get a really robust investigation on things that maybe don't rise to a level where somebody's actually, you know, threat of death or injury. One of the really great things that we have now is obtaining an elder abuse restraining order. As of January 2023, an interested person, if they see some isolation of a party, isolation is now something that can be used in the elder abuse restraining order to ferret out bad actors and predators so that they can be prevented from further abusing and harassing. And as long as you have that documentation of the past event, that's where it's going to be really, really helpful. And it is a court proceeding. It's a fast proceeding. A temporary restraining order is typically issued. And then if it's not contested, it will turn into a permanent restraining order, which will further protect the elder. Next slide. So additional legal actions available to address elder abuse. Next slide. There are civil actions. We can seek compensation, and including in those are breach of fiduciary duties. If somebody has breached their fiduciary duty, so say it's a power of attorney, an agent who took the money and started self-dealing, there could be additional damages that could be collected for the financial losses, including pain and suffering caused by the abuse. There can be criminal complaints. Very many times in my I do civil litigation. A lot of times there's a corresponding criminal complaint going on, and I have worked cohesively with criminal investigations to prosecute the abusers. And I know early in my career, there was a very, very egregious abuse, and the gentleman was sent to Ecuador by his caregivers and he was tricked and thought he was going on like an immersion trip to learn Spanish for 2 weeks, and he ended up there for 5 months and had to finally get the consulate to get back. And by the time he got back, his housing was sold and the elder abusers had taken all the money that he had to live. And that was a very sad case. We did end up getting some of the money back. I find that with financial elder abuse, it's getting the elder abusers spend the money. So there's nothing really that concrete to get back. However, you know, if there's properties that they've transferred into their name, a lot of times that's where we can get some money back on actual real property. And then I have been able to see some of the abusers go to jail. And that, you know, that's something that needs to happen more, and there needs to be some steeper penalties. Also, I find that if there's an elder, a power of attorney must be revoked, and you know, you might have to open up the probate court action to challenge and invalidate suspicious wills and trusts. That could happen while the elder is alive. It can also happen after the elder has passed by family members. If there's wills and trust activity and the elder has representation, it may be smart to undo the things while the person's alive. Next slide. So some parting advice. I think we all need to really collaborate, and we have to combat financial elder abuse. We need to get law enforcement to investigate the case. If you're the supporter for a vulnerable elder and you're kind of coming in and there's already been some abuses, trying to help get law enforcement to give them some evidence and get abusers to justice. With social workers and APS, identifying and supporting victims, connecting them with resources, providing ongoing assistance. With attorneys, we need to provide legal guidance, represent the victims, and pursue appropriate legal actions. I'd also like to say something about trust and estate attorneys. I think it's more important than ever that conflicts are evaluated on who you are representing. And I've seen far too much conflicts going on in this area. And lastly, communication with the community, which we're doing right now, awareness and training professionals. Next slide. Questions, and thank you.
Thank you so much, Edie. That was a very wonderful and informative presentation. We do have a couple questions for you from the chat or from the Q&A box. So the first question, once you have an SDMA, do you share this with doctors, banks, financial institutions, family members, etc., so there's full awareness that the document exists?
I definitely advise that that's how you should go about it. Now, I think there's going to be an uphill battle to get financial institutions to recognize it. I do think that the medical community is going to be very receptive. I think it's going to be harder and harder with the banks. So they need to be made aware that this is a new law, that this is a notarized document, this is the will of the vulnerable elder, and this is something they need to accept.
Okay, thank you. Now the next question says, what law, if any, prevents banks from refusing to accept a client's power of attorney? They had mentioned, or this person mentioned, they have had banks reject them on the regular. Sometimes they want their own forms, but often they just refuse to comply.
So there is a probate code. I'm going to try and see if I can find it really quick. I typically will tell them that it's the law that they must, because one of the issues with the law, if they have a suspicion that somebody's trying to nefariously get into somebody's bank account and this power of attorney is not going to be accepted, that is going to be okay for them, but they have to show some kind of, probable cause not to accept it. Having their form is not okay. That is not a good enough excuse. And if they persist in not acknowledging a properly notarized document that was signed and is clear and it's on the uniform statutory form, then you can file in court, and the bank, the financial institution, will be responsible for the attorney's fees. And so as soon as you point that out to them, they will turn it over to their legal department, and they will absolutely have to look at it a little bit differently.
Yeah. Okay, thank you. Now to follow up with that one, someone said it was mentioned that financial institutions legally need to accept the person's own power of attorney, not requiring their form. Where is that codified? Is that the code that you had mentioned?
Yes, and I'm sorry, I don't have it. I don't have it on the tip of my brain. I'm going to try and look it up while we're here. But if you want to go to another question.
Sure. So someone asked, what if you want to have more than one supports, like siblings in a family?
Then you can have co-supporters. Now, on the SDMA, there's different areas. So you can have a supporter for finance as a supporter for healthcare, or even within the healthcare and within the activities of daily living, have different people to help you with bathing, and then with you can really drill down and make it as specific as you want. Now, you can also have co-agents for power of attorney. You can have co-conservators that you nominate in any estate planning documents. And I do recommend that everybody, regardless of what your age is, look at having just the base documents, having a power of attorney for finance, having a power of attorney for healthcare or an advanced healthcare directive at a minimum. If you own real property, especially if you own real property in California, I most definitely recommend that you have that property in a trust so that those trust terms can be abided by and you can avoid probate altogether after passing. It is extremely helpful. So I'm not sure if I got off topic on that.
You're good. Yeah. So basically you can have multiple people on
yes,
as supports. Yeah. Okay.
I do want to say one thing about that though. When you do have multiple people, and a lot of times, there may be two siblings, so they don't want to upset the apple cart. As long as the two co-agents, co-conservators, co-supporters, as long as everybody is on the same page, as soon as you get infighting or conflict, that's when you're going to end up in court. And so really all of these predeterminations by the person are going to help stay out of court, because the last thing you want is your family to get dragged into court, and then all of a sudden there's warring, and all of the assets that are supposed to be going for the care and well-being of the elder are all of a sudden being spent on legal. It's just not fair to the elder.
Yeah, for sure. Okay, so we do have another question here. Do any of these processes, probate, conservatorships, interact with living trusts, or does one supersede the other?
So after a person passes away, so first of all, the probate court is a court of equity. And the things that happen in a probate court, there are the elder abuse restraining orders, there are conservatorships. And like Katherine pointed out, there's the LPS conservatorships, there's guardianships, there's limited conservatorships for disabled people, there's conservatorships of the person, conservatorships of the estate. And then on the flip side of that, after the person has passed away, then you have probate. Now, what I've seen in some conservatorships is you could do what's called a substituted judgment. And if the person that's being conserved doesn't have a will and doesn't have a trust, but say they own a large piece of property, and in California, that could mean it's $2 million, and there's no trust, rather than having it probated, they could put it into a trust through a substituted judgment. It's court supervised, and typically that helps to alleviate the court and the family from having to go through probate after the person passes away. It's still court supervised. And one of the things about that process, having the trust in place, a court supervised trust, is you're going to be able to have a lot more controls, because there are annual accountings and scrutinization on where the funds are being placed. And somebody can't just come in, and because an elder is in assisted living, it may be that the house needs to be sold in order to fund the care for the elder. But so one of the things I'm going to say about substitute judgments is it will follow probate intestacy laws. And probate intestacy laws means if you didn't make a will and you didn't make decisions on who's going to get what's left over when you pass away, then the state of California is going to make that decision for you. And it's very specific, and it flows a certain way. And if you're married, it's going to flow a certain way. And that's all going to be put in there. So if you haven't made decisions and you get conserved, and then the conservator does a substituted judgment to put everything in a trust, it's not going to be to your friend or a caregiver. It's going to be according to the intestacy laws in California. And that's how it's going to flow. Oh, so I'm going to just keep talking about this area. So a trust can also end up being contested so if a trust isn't contested and it's really straightforward, mom and dad, they have a trust, mom leaves it to dad, or another scenario is mom and dad, once the first person dies, they split it into two trusts, one becomes irrevocable, the other one's still revocable. So there's a lot of trust law that kind of gets fairly complicated, which is why if you do not have the requisite capacity to make a trust, because it is a more complicated document, that trust document, if it's signed by an incapacitated person, can be set aside, especially if that trust was made to a caregiver, which I have seen more and more and more common, is the caregiver realizes there's not really family around and takes the vulnerable elder to a trust and estate planning attorney, and all of a sudden there's a trust it's funded with the real property, and now a caregiver is getting a very large gift. Now, in that instance, the code at Probate Code for California has put some safeguards in place. So if it is a caregiver and they become a beneficiary, they are going to be presumed to be fraud or undue influence. That's a presumption. It means that it's not going to be valid unless there's an independent certificate of review that is done to validate that there wasn't undue influence and there wasn't any kind of capacity issues at the time this was done. So where writing a will is fairly simple, if it's in your own handwriting and you have, you've simply, you date it, you do everything in your own handwriting and you sign it and you put your wishes down, that document can be brought to court and probated, but it's not going to skip over. A trust skips over probate. A trust ends up having a trustee, a successor trustee comes in, and then that successor trustee manages all of the assets and distributes according to the terms of the trust. Where the probate court comes in is when there's, say there's some ambiguity, you don't understand some of these terms, you can, say you're the trustee, you can do a petition for instruction and go into court and ask the court to determine one of the clauses, to figure out the heirship, there's so many different trust actions that can fall under what's called Probate Code 17200, which is you're going into court to ask for some guidance on these trust terms or to invalidate a trust. So that's a whole nother topic for another day, I think, but certainly the probate court handles a lot.
Yeah, so we do have a couple more questions, and just so where can someone download the SDMA form, and where can they find free conservatorship filing assistance in Orange County? Do you happen to know?
So yeah, first of all, you can go online and just go ahead in your search engine and type in ACLU supported decision-making agreement sample. And I think you can get it on that website. I like that one. You could take that, you could change it up. California, to my knowledge, doesn't have one codified yet. Now, as far as getting judicial council forms for the petitions for conservatorship, those you're going to go on to judicial council and look at court forms and then look up conservatorships. To get free advice or free legal advice, you can take those forms, fill them out, and then usually in Orange County and in LA, there's usually some self-help clinics that you can find. You can bring all your papers in, they can look them over, and then as of now, there's a electronic filing requirement. I think if you're in pro per, which means that you don't have an attorney helping you, they may allow you to file in person. Typically, if you are a fiduciary, you're going to need to be represented by counsel as you move forward with accounting. So the local rules don't allow typically for an unrepresented fiduciary, meaning an unrepresented conservator or an unrepresented court supervised trust, to not have counsel.
Hey, awesome. Someone had mentioned, does a trust need to be done through an attorney? And if you could please repeat what you mentioned about having assets like a home in a trust.
Sure. So you don't necessarily have to have a trust drafted by an attorney. Here's the caveat. There is LegalZoom, there's all kinds of stuff. I litigate trust litigation. So I litigate trusts. I have seen the whole spectrum of trusts. A lot. Ooh, I don't know if you hear that.
Yeah.
Sorry. Yikes. A lot of times these trusts that are done not by an attorney, they're just forms and they are awful. I mean, these are what cause a lot of litigation is poorly drafted trusts. So yes, having a trust professionally drafted and having all of your estate planning done by an attorney may be an upfront cost. It may save you, 5 figures, 6 figures of legal fees down the line. And another thing about just the forms, I don't think they go in as depth as an estate planning attorney is going to go with you, because you have to look at your family situation. a lot of times we come from blended families. There's a stepmom, there's a stepdad, there's kids from here, kids from there. All of those kind of have to be looked at really and written properly. If they're written improperly, that's when you're going to see yourself in court, see your family in court. Also, the trust document can contain your wishes for nomination of a conservator. If there is a conservatorship needed, that can be done in your advanced healthcare directive. That can be done as a separate standalone agreement. Usually a trust and estate attorney is going to walk you through the whole package of what can be done and get you so that you've taken care of business, which I always say it's the once you do your estate planning, you feel like an adult. Before you do your estate planning, you're still you haven't taken care of things. Nobody wants to look at their mortality. It's very difficult to really, deal with some of these decisions. But I have to tell you that as a professional, it was really relieving to me once I finally did my own estate plan and my own succession planning. And what happens if I am not here tomorrow? How are those pieces going to fall? So if you're a professional as well, it's really important to get your estate planning done. Otherwise, you're leaving it up to the state of California. And in my case, I'm an attorney. If I didn't have my succession planning done, then the state of California would come in and take over my practice and make decisions that I wouldn't necessarily want for my practice or my clients. So it's always better to do your own contingency plan. You think about it once, you do the really hard decisions. It's also recommended that you do it if you have a family and you're young. And these documents, once you have them in place, they can follow you. And if they're done properly, instead of, I get it, you want to save money and you want to do self-help, but if you don't know what you're doing, you want to ask for the advice of a professional. I think it's really important.
Right. Yeah, for sure. And I'm not sure if you did discuss having assets like a home in a trust.
Right. So there's a couple different ways you can handle a home to keep it out of probate, because real property, if it's just in, Jane Doe as a single woman, if that's how it's titled, it's going to probate. So you need to look at if it's joint tenancy with right of survivorship, that joint tenant is going to get the property without having to go through probate. It's going to be just as a matter of law, the joint tenant will get it. But you do have to file papers to do an affidavit of death of joint tenant. The other way to hold property, there is a pay on death. That's kind of a newer tool where you have your property and then it says pay on death too. There's a lot of different things now as far as parent-child deductions and Prop 19, which the way the law used to be with property tax, with property tax, there could be ways to hand down your assets to your children. They're much more restricted since Prop 19 passed. So having a trust can allow for a trust to be able to, once the person dies or the couple dies, that say there's a couple of kids and one of the kids really wants the house, rather than it going, 33, 33, 33 to each kid, one kid wants it and it's offset by some other assets. That's where you have a lot more planning tools post-mortem, meaning after the death of the trustors. You can put in clauses so that people can take advantage of any kind of property tax benefits, other tax benefits. In addition, if you have the property, the real property in a trust, it not only will avoid probate, but it also will allow for, you could have a life estate in it. You could, say one of your children is special needs. And if they inherit, all of a sudden, all of their benefits, all of their public benefits go away. Those public benefits could be invaluable in sustaining and keeping that person independent. And now all of a sudden, all of these assets come in and destroy the benefit structure. So you could put in a trust specific language to have a special needs trust set up, to have different terms. Spendthrift is another term, which means Say you have somebody with a creditor problem. You don't necessarily want everything to go to the sibling or to your child that has huge credit debt. So the spendthrift can kind of manage that. So it really is valuable to do some estate planning and include a trust if you have real property.
Got it. Okay. So when last person commented, the probate code 4306 was the language allowing reimbursement of attorney fees for refusal to accept the POA. I think this was referring back to
Yes.
the bank. So probate
Thank
code
you.
4306. Thank you so much.
Yeah, and I would print that probate code out and take it with you to the bank. And I've seen them go, oh, okay. And then all of a sudden they're accepting your properly notarized, authentic document that gives you power to be able to take over, mom's account so that you can pay the mortgage or whatever it is. There's also ways to get around that. Some other least restrictive means is you could go on as a joint tenant of the bank account. Sometimes I see problems with that with other siblings. You want to try and minimize the downside of any kind of litigation after somebody passes away and while they're alive. But the financial elder abuse can be exposed after somebody has passed away, and all of a sudden there's a 4-year statute of limitations after somebody has died to go in and look and see if financial elder abuse has happened during the person's life. And so that's another probate case that can be brought after the passing, is a financial elder abuse case.
Okay, awesome. Thank you so much, Edie.
No problem.
We are at our last couple minutes, so I will go ahead transfer this over to Maika to start wrapping up. Thank you so much, Edie, for your presentation, for answering those questions.
Thank you so much for allowing me to just speak on this topic. I am passionate, and I do want eyes open and community support. There's vulnerable elders out there and they don't have supporters, and we need to identify who those are and try and become their support.
Thank you. Thank you so much. Such valuable information, Edie, and thank you so much, Jennifer. Now I'd like to introduce Kim Nguyen from Orange County Social Services to provide our closing remarks.
Thank you, Maika. We would like to thank all of our presenters today for their time and their invaluable information they provided. I also like to personally thank our committees and all of their hard work to make this event possible. And most importantly, we thank all of you for being here today. You will receive a survey by email shortly. We would appreciate it if you would complete it and provide your feedback. If you participate in the survey following our webinar, you will be entered into an opportunity drawing to win a $250 gift card from Amazon. There will be a total of 25 winners. You must provide your full name and age range when completing the survey to be entered into the drawing. In addition, you will receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar. We would also like to thank our sponsor for today's events, Optima Health and Radiance Futures. Again, on behalf of our committees and our presenters, thank you for joining us and have a great rest of your day.